You can testify in a deposition or in a trial. Lawyers use the same questioning techniques in both places, and you should learn to use intelligent responses as well. Let's start with a few examples. Mr. Expert, would you state your name for the record? My name is John Q. Expert. I live at 15 Central Avenue, Ashland, Oregon, 97520. My phone number is 949-555-1467, and I work as a sole proprietor under the name Computer Options. Observations? That answer was terrible. You may think that they will ask for those things anyway, so why wait? You were only asked for your name, yet you gave an address, a phone number, and even information about your business. You were only asked for your name. That is all you should have given. Here's what the other lawyer gained from that seemingly innocuous response of yours. In what was probably the first question of the deposition or trial, you gave away your inexperience completely. You showed that you do not listen carefully to questions. You do not only answer the question asked, and you give much more information than required. You are probably going to be an easy mark during the rest of the testimony. Your own attorney is already cringing, and the other attorney knows that you are going to make his job much easier and help his case. That was bad. Here is a good example from a deposition. Question. Mr. Expert, do you have an opinion about why the building collapsed? Answer, yes. Question. What is the basis for that opinion? Answer, my entire investigation of the case. Observations. Those answers were good. Nothing extra was given, and the attorney has to decide how and whether to probe further. He may not go farther, choosing to rely on what you have already written in your expert report. That allows him to move on to other areas, and allows you and your attorney to avoid telling any more at a deposition and saving it for trial. Now here is an ugly example. Did you study the contents of the hard drive? Answer, I sure did. That guy's so guilty, I can't believe it. He had more than 700 pictures of pornography on his computer. There were more than 24 searches for information about hunting knives, just like the one that was used in this murder. And there was an entire chat room full of conversation about terrorist plans. Okay, I stretched it a little bit there. But observations, that was the ugly. Your answer should once again have simply been yes, and then waited to hear what else might be asked about your study of the hard drive. Here's what the other lawyer gained in that interchange. First, you made a legal judgment by saying that the defendant was guilty. That may be your opinion, but you have no legal right to say it. Tactic here. You're not qualified to offer a legal opinion, don't do it. You are only qualified to bring your expertise in your specialty to the court. Do not make legal assessments or judgments. Second, you disclosed 3 significant things that you did. Namely, you found pornography, you discovered internet searches about weaponry, and you discovered chat room conversations about terrorist plans. Those unrequested admissions provide the opposing attorney with 3 completely new areas about which to ask you questions. He may not have planned to ask questions about those areas. Worse, those 3 areas may provide no support for the real opinions that you plan to offer to the court. You may end up on the defensive for even having been asked to look at or look for that particular information.